in, Clark County. It's Rob Anderson with Reform Clark County, and today we're going to be taking a look at the importance of honesty and should elected officials, be held to a higher standard. And but before we do, hit the like button, share this, share it with friends and family, and help support the show. You can go to givesendgo.com, Reform Clark County, and really support the legal efforts, which you're going to hear more about later, and all the other things that are going on. It really helps as we try to reform Clark County. So let's talk about Councilor Wil Fuentes. So he was sworn in early January 7th, I believe, and he was, off and running. In fact, just a few weeks after being sworn in, he would propose to eliminate prayer invocation from council meetings. He would actually go as far as removing the Pledge of Allegiance, which later after a big uproar, he backed off and apologized for. But it was pretty clear that because of our Pledge of Allegiance mentions God in it, he was very uncomfortable with it. So the first few months of office were a little rocky for Mr. Fuentes, but one of the things that's required of all elected officials within 90 days, they must complete OPMA training. What is that? That's Open Public Meetings Act. And there's state required training that's RCW 4230-205, in which says, and it's required, and it's not a maybe, it's not a suggestion, you have to complete OPMA training. Why? Why is this so important? It just makes sense because OPMA dictates how business is going to be conducted, and it's going to be conducted in the open. It's going to give the public a fair chance at giving input before decisions are made. You can't have closed meeting decisions. There can't be serial communications, meaning that one counselor talks to another counselor ahead of time. So there's certain ways, and there are particular procedures that have to go in decision-making process, or it becomes just like cronyism and closed door and the public is shut out of it. It's very important, so much so that the state law requires OPMA training within the first 90 days of you being sworn in. When did Councilor Fuentes complete his OPMA training, which would have been due April 7th? Well, I can tell you it wasn't completed on April 7th. It wasn't completed on May 7th or in June or July, but August 18th is when Wil Fuentes finally got around to completing his OPMA training, over 4 months late of what he was required to do. Now, hey, when you're first elected, I'm sure there's a lot coming at you, but this is one of the big requirements is complete your OPMA training, because we don't want you to make decisions that could be illegal, that could be improper and violate the OPMA. But we see that Wil Fuentes just completely disregarded it. In fact, probably, I'm guessing at this, the only reason that he completed it on August 18th is because on August 17th, the attorneys that were representing him had to produce his OPMA certificate of training and could not, and sent me only 3 of the 4. So Marshall, Little, Young, but not Councilor Wil Fuentes. Why? Because he hadn't done it. He didn't complete it. And it was only because of my discovery request that probably led him to do so. Now, why is this important? This is important because OPMA, like I said, there's certain ways to go about decision-making process, and one of them that you can't do is go around and meet with counselors, especially with 2 other counselors or with a counselor who then talks to another counselor, so a chain of 3. You can't do that. But we see that maybe that Mr. Fuentes just didn't understand the law at this time. Because you might be thinking, well, hey, there's a lot going on. Maybe the county didn't tell him. But as I did a public records request and saw the documents, I saw that multiple times. There were multiple emails before he was even sworn in that told him about the requirement of OPMA training, how important it was, and that he had to get it done, and this is how you get it done. And he disregarded it. He didn't do it. Multiple emails in which went out and to let him know on his onboarding process and others, and he just didn't do it. Finally, a county staff member reaches out to Councilor Fuentes on March 7th. So this is just 5 days before the infamous Belkot removal meeting on March 12th. So on March 7th, the county staff reaches out via text to Wil Fuentes saying, have you completed your, can you confirm that you have completed your online OPMA training, please? Wil Fuentes responds back like a minute later saying, and get this, what is OPMA training? This is March 7th. This is 2 months into his office, multiple emails of county staff telling him about OPMA. In fact, there was a little refresher for the other county councilors in January, at the end of January, just a couple months before this. Clearly, I guess Wil Fuentes was sleeping during that part because he says, what is OPMA training? And the county staff member says, Open Public Meetings Act. Councilor Fuentes responds back, I don't believe so. The county staff member says, okay, let's talk before you leave. And he replies back, sounds like I'm in trouble, smiley emoji. Well, he wasn't then because he'd still have 1 more month to complete his training. An email was followed up that day by the county staff member that I saw that told him about the OPMA training, in which he completely just blew off. He didn't do it in March, didn't do it in April, May, June, July. It wasn't until August, it wasn't until my discovery requests that he finally got around to completing his online Open Public Meetings Act training. So this is clearly a violation of his oath of office. Part of your oath of office is that you will complete your duties that have been charged to you as a part of that office. And the real main duty that he had for the first 3 months was to get his OPMA training. And we could see why the importance of it, because just, on March 7th, when he says, what is OPMA training? 5 days later, he's going to be in a situation where did OPMA violations occur? Because it sure looks like it. And based on this, Wil Fuentes wouldn't know OPMA from, the CIA. Like, he wouldn't know the difference. So how can we trust that he actually followed the law, as his declaration on April 23rd implies that he didn't do anything wrong? So let's talk about another matter that's equally important, and that is it revolves around honesty. It revolves around, should public officials have a higher standard or a standard of honesty when they serve in office. So we've already covered that on March 7th, Wil Fuentes didn't know what OPMA was. On March 12th, he made the motion to remove Michelle Belkot. And then on April 23rd, he submitted a declaration to the court in Skamania County saying about that he did not prepare the motion to remove Michelle Belkot ahead of time. Now, why is this important? I've already covered a little bit of this in OPMA, that you can't have serial communications as counselors regarding decisions in issues that involve a decision, that you must do it in the open. It can't be done, ahead of time. Now, we do already have evidence that there was a chain that Sue Marshall was communicating, for example, with Matt Little. So on March 11th at 11:11 p.m., just a couple hours after the C-Tran meeting, she sent Matt Little a text saying, "Can we check in before council time? Thanks." So that's one other counselor. We also know through emails, through the public records, that she also reached out to Councilor Glenn Young, giving him a link to the C-Tran meeting and saying, if you have any questions, call me. And then later on, Councilor Young sends a text message to Sue Marshall. This is all right before the March 12th meeting at 1 o'clock, sends a text message saying, "Can we talk?" So we already see the evidence of chatter that's going on. But what about Wil Fuentes? Was Wil Fuentes a part of this? Because he is the one who made the motion, read a motion to remove Michelle Belkot in an April 23rd declaration to the court, in which he said, "I declare under penalty of perjury under the laws of the state of Washington that the foregoing is true and correct." He stated that he did not prepare. In fact, Section 7 says, while taking notes of Councilor Marshall's report, I wrote a proposed motion to remove Councilor Belkot from the C-Tran Board due to her not following the council's directive. I put in a public records request and got that exact note in which he says he read from, that he wrote it out in his own handwriting. This is the motion to remove Michelle Belkot that he's referring to. And he says clearly that he did not prepare it ahead of time and that he wrote it out during Sue Marshall's report. The next thing he says is the council discussed what occurred on March 11th, 2025 C-Tran meeting. Councilor Young stated that if a councilor did not follow a directive of the council while serving on a board, the councilor should be removed from their board position. Councilor Young's statement prompted me to make my motion to remove Councilor Belkot because I now believed at least one other councilor might support it. I made the motion to have Councilor Belkot removed, and we know what the outcome of that was. So why this is important is, again, OPMA says that they can't ahead of time. And if he prepared his motion ahead of time, which we're going to look at some evidence that suggests that he did, then that's a problem. That's a big problem. It shows that he knew ahead of time with Sue Marshall about removal. And with Glenn Young making a motion or bringing up the idea, was there coordination overall? But what I'm going to show you now is the video. Enough of me talking. You look at the video, because there happens to be video in which a camera was trained on Sue Marshall and Wil Fuentes the whole time. Now, I had to blow this up a little bit because it's a very small box on the screen, but you can see enough to see what is going on with his hands, what's going on with his body, and I do not see at any time enough time that he would have needed to write out this motion. So this motion, it's about 40 plus words. I figure writing it out, it would take between 45 seconds and a minute of handwriting to write this out. And there's also some kind of corrections here. So, at least probably a minute worth of writing. So I want you to look at this video. It's a little long. I'm going to speed it up, in which you can then tell if you see Councilor Wil Fuentes write out the motion to remove Michelle Belkot, which he says in a sworn declaration to the court in Skamania County that this is when it happened.
I actually have a report. I wanted to report back on the C-Tran meeting. I know the council spent a lot of time deliberating.
Okay, so I've stopped this so that you can see, because this is a great example of what it looks like for Wil Fuentes to be writing. He's clearly not writing out on the motion or the paper that he wrote the motion on. This is a stapled, probably agenda related to this meeting, but it's definitely not what he wrote the motion on. So, but this gives us a great visual of what it looks like for Wil Fuentes to be writing. Remember, we need to be looking for something that is at 45 seconds to a minute long of him writing, but this gives us a good framework of what we're looking for.
On the vote that was coming up before C-Tran. And I guess it was a long meeting, but just to, I guess, put this as succinctly as possible, the motion, whether or not to have permissive language for C-Tran related to O&M for light rail, which was adopted by the C-Tran.
Here we see Wil writing again, but the problem is that Sue Marshall hasn't really laid out at all the details. So this can't be the motion that to remove Belkot, because she hasn't really begun to tell anything of substance yet, and he only writes for about 15 seconds. But again, this wouldn't be or could be the motion, because Sue Marshall hasn't really laid it out yet. What happened?
Board in November and came back to the C-Tran Board last night for reconsideration. So Councilor Belkot moved to go back to the original language, which would not be permissive. And does anyone want to make a proposal?
I move to remove Councilor Belkot from the C-Tran Board as a result of not adhering to County Council's direction on the vote of 4-1 to keep the existing MLPA language related to the O&M in light rail.
Now, I know that was kind of tough to muscle through, but as I've watched it multiple times, I can't see it. There's a few times when he reaches up, it looks like he might for just like a second or two, and then that's it. But there is at no time in which he has, it appears that on video, that he does not write out this motion. And again, you think, Rob, big deal. Well, it is a big deal, because in a sworn statement in threat of perjury to the Skamania court, Wil Fuentes says that he did not prepare it ahead of time, that he did it during a specific time during this meeting, and the video during that specific time does not back up his claim. Is Wil Fuentes being honest about when this is? And, you know, without OPMA training at this point, who's to say that he didn't know that he couldn't come with a prepared motion and have coordinated with some others potentially on it? But that's where we are with this, and it appears that he committed perjury. It appears the video evidence shows that he did not write out this motion to remove Michelle Belkot during the times that he says he did. So what's going to happen in this? should he be held to a higher standard? So what we find out in just the first 3 or 4 months of Councilor Fuentes' time in office, he failed to get his OPMA training and potentially lied to court in possibly committing perjury. So it really comes down to, what is the standard that elected officials should be held to? Should they be held to a higher standard, or how about just a basic standard of honesty, that when you say this is what happened, that's what happened? But unfortunately, there's some real big questions that have to be answered here, and that's why I'm taking legal action. I'm taking legal action through getting declaration relief from the court, be looking at potential recall submission to the auditor's office, and also ethics complaints I'm considering to file. Now, I know what you're thinking. The Ethics Commission is completely broke and will only apply the standard of ethics violations if it involves financial gain. So if, Wil Fuentes happens to receive a big bag of cash because of not getting his OPMA training, or potentially perjury in a declaration filed to a court, it's not an ethics violation. That's so far how they're applying it, which is crazy, bonkers, because Section 13 of the HR policy manual doesn't just put it in a keyhole that it's only financial gain, that there's issues of professionalism, of honesty. There's all kinds of aspects of ethics that are just completely being ignored. But I'll probably file them anyways, just maybe to demonstrate how wild and wrong the Ethics Commission is. But I'm going to file these things against Wil Fuentes because he didn't fulfill his duty of oath of office. He had basic duties, and it appears also that perjury is a potential here. So we're going to move forward with those, see what happens, because public officials should have higher standards, and the public should demand that they complete all of their duties that are required of them by law, and to do it honestly. So we'll move forward with that. We'll see what happens. So that's Reformcast for this week. I really appreciate your support, and hit the like button, share it, get the word out, because Clark County, you need to know what's going on in your backyard. And if you want to support my efforts, the legal efforts, this is very expensive. It's very time consuming. If you want to help support that, you can by going to givesendgo.com, Reform Clark County. And thank you for those that do support, and we'll see you next time. And remember, you, with God's help, are the catalyst of reform. See you next time.